The police arrested a firefighter for criticizing his bosses online in a private Facebook group and then told him that his bail conditions meant that he couldn't even tell people that he'd been arrested. Now, it seems a daily occurrence that we get these stories of the curtailment of free speech and the ostensible abuse of police powers, and we absolutely must resist it. Not resist in the sense that you break the law, I would never encourage you to do that, but we absolutely must protect the right to free speech. So if you value free speech, please do give this video a thumbs up because it spreads it to a wider audience, otherwise it might get suppressed. And please do hit that big subscribe button below because about half of you still don't do that. I am your alternative to the mainstream media. I will talk about these things when the media won't. I will tell you what the law says when the media won't. And I will tell you the limits so that you know when you are able to fight back against these things, when they are an abuse of power. And if you are worried about digital ID, I strongly encourage you to watch my Black Belt Secrets video, which I will pin in a comment. I'll put it in the description because this is coming, whether we like it or not. So you need to understand exactly how that's going to work. So now let's go to this story below. I will link this below. This is from the Telegraph. The police used Orwellian powers to gag a firefighter to prevent him even revealing the fact that he'd been arrested after posting messages online criticizing his bosses. This is, with all respect to the police, this is absolutely ridiculous. They said that his freedom of expression had to be limited to maintain public safety and order following his arrest on suspicion of malicious communications. So in this video, I'm going to tell you a little bit about what those bail conditions are allowed to be and what they are not allowed to be and what you might challenge in court. Not legal advice, you understand, but generally speaking. And in this case, a special bail hearing, the court overturned this so-called gagging clause among the fears that officers were behaving as though we lived in a police state, which of course we don't. Now this man, Mr. Moss, was never charged with a crime, but he had his home raided. He believes the police had been heavy-handed, they'd been weaponized to silence him, and so on. And this is absolutely disgraceful. So let's talk very broadly, first of all. A gagging order, i.e. you are not allowed to talk about XYZ thing, is generally something that only the courts can impose, not really the police. There are certain things the police can do if you are arrested on suspicion of an offence, and they can impose these restrictions upon you, and they are either categorised into pre-charge bail, which are generally not as restrictive as when you've been charged, or post-charge bail. So if you have been charged with an offence, then it means that they have met the evidential and public interest test thresholds to charge you with an offence, and then they can impose slightly stricter conditions on you. But broadly speaking, they must come into a certain category, and there are requirements for any such conditions. Now, we've known all sorts of bail conditions, such as restricting somebody from going home because they've been accused of harming one of their family members. Now, you have to look at this from an objective standpoint. If the allegations are correct and true, then obviously it is in the best interest to protect the family from this individual and prevent them from going home. If it's all false, and then they are kept out of their own home for months and months on end, then that is obviously quite unfair if they turn out to be completely innocent. Now, the broad scope of police powers for bail, it must be necessary and proportionate to impose any condition upon you. There are usually time limits involved, so initially that will be for a period of 3 months from the bail start date, extendable by 6 months by an inspector, 9 months by a superintendent, and beyond that, it needs to be extended by a magistrate's court, in which case they need to provide evidence and so on. And for certain especially complex cases, extensions of up to 12 months by senior officers, and no time limits apply to CPS charging decisions under Section 37 of PACE. Now, all of these powers come about through a collection of bits of legislation, including the Police and Criminal Evidence Act of 1984, the Bail Act 1976, and there are certain codes and codes of practice and guidance from the College of Policing. But none of which necessary to go into for this video. This is an overview of what they can and can't do. So let's take a look at pre-charge bail, what it is intended to do, and the conditions that they can and cannot apply to you. So overall, it is intended to secure the following points. to ensure that the suspect surrenders to custody at the end of the bail period, in other words, they come back to court to face accountability if that's necessary, that they don't commit further offences whilst they are released on bail and have not yet been charged, that they do not interfere with witnesses, because obviously that would be detrimental to the criminal justice system, and that they don't otherwise obstruct the course of justice. And of course, witnesses include the victim. So they can impose conditions on you that satisfy any of those requirements. And so in order to achieve those requirements, they can set certain conditions on you. And that might include a ban from leaving the country, and that includes the requirement to surrender your passport, not being allowed to enter certain areas, such as the home or the area where the alleged victim is likely to be, even adherence to a curfew, because some offences may be time-specific and so on, residing at specific addresses, although it should be noted that they cannot impose conditions to reside at a bail hostel, not being allowed to communicate with certain people, such as victims, witnesses, and known associates. But considering all of these, they must also balance the human rights aspect. So that includes the right to the freedom of expression. So none of these, unless they are specifically communicating with witnesses or alleged victims and so on, none of these would include the general prohibition on talking to the media, talking to the press, etc., so long as it is not obviously intended to pervert the course of justice and so on and so forth. But generally, talking to the media is not something that they can generally curtail with those objectives in mind. And of course, once a suspect has been charged, those conditions can become more onerous, but there are still certain conditions such as electronic tagging and so on that can only be imposed by a court. And there are also rules to do with murder, manslaughter, and serious sexual offences as well regarding bail. But otherwise, there is a general presumption in favour of bail, unless there are grounds made out against the rebuttable presumption in favour of bail, such as there are substantial grounds for believing that the suspect would fail to appear, would interfere with other witnesses, or would commit further offences, or in some cases for their own protection, and so on. I've done other videos talking about that, but generally speaking, these cannot curtail the right to the freedom of expression unless it's absolutely necessary for one of those scenarios to protect witnesses and so on. But that would not be, in my view, a general blanket ban on talking to the media or telling people that you'd been arrested. And so that could well be argued as an abuse of power to restrict somebody from talking and to make them feel intimidated and therefore not be able to get the assistance that they might require. And so coming back to this story then, this firefighter that was arrested for messages on a private Facebook group said that they were certainly not criminal. And yet at 7 a.m. the police raided his home, seized telephones, an iPad, a computer, and said that he felt like a criminal. He was given bail with 6 conditions, including the prohibition on posting any communication online or otherwise related to the country's fire service, its chief and deputy fire chief officers, posting messages relating to the police investigation, and so on. But Tom Beardsworth, hired by Free Speech Union, now not a sponsored video, but if you value free speech, I suggest you join Free Speech Union, I'll link them below, told the court that Mr. Moss was a man of good character and should have been dealt with by a voluntary interview rather than a police raid. All sounds a little bit draconian to me for messages that somebody obviously presumably found offensive, which is not an offence, by the way. It is not an offence, despite the fact that police up north somewhere even went to the extent of creating, paying for, and driving out a mobile billboard to say being offensive is an offence. It is not. It is not an offence to be or to say something offensive, contrary to what all that said. And I believe the force since apologised because they didn't understand the law. But all of these things are quite draconian. We need to toe these lines so that people understand, which is why I do my videos and why I ask you to subscribe. Now, whilst this firefighter didn't challenge 4 of the conditions, such as contacting the alleged victim and so on, he did argue that 2 of the conditions limited his freedom of speech, which is obviously contrary to the Article 10 right to the freedom of expression. And finally, Lord Young says it's not against the law to criticise someone in authority. Not yet, anyway. And it shouldn't be. It is not an offence, and it should not be an offence, and police should not be arresting people on suspicion of criticising someone, offending someone, or even sending something that people find indecent and offensive, because the law is very clear in this regard. Unless it is grossly offensive, and this really does mean grossly offensive, and it's usually not just one message, even if one message is horrible, It's usually not limited to one, but even if it is one message, it needs to be grossly offensive to cross that criminal threshold. And as I've asked before, if you are a current or a previously serving police officer or even fire officer, let me know in the comments whether you've had experiences like this and what you think about stories like this, because I respect the police. The police have a difficult job as it is, but stories like this with malicious communications, which I've had to deal with a number of times in the last few weeks, do harm the relations between the public and the police, who otherwise may be very supportive. So let me know in the comments what you think. Like this video if you appreciate free speech, subscribe to the channel, and I'll see you in the next one.